And it is streamed as
Okay,
well.
awesome. Hello.
Even better.
everyone out there. Even better.
Hello world,
I will
yes.
try not to embarrass all of us here in Southwest Florida. My name is Suzanne Boy. I am an employment lawyer at Henderson Franklin, which is a couple of blocks down the street. If you haven't heard of our firm, we have about 55 attorneys who do just about every kind of civil law you can think of. Employment law, obviously, corporate law, real estate, land use, family law, work comp. I'm sure I'm forgetting people that I'll get in trouble for, but any kind of civil law, we do it. When people ask me, what do you do as an employment lawyer, I describe my practice like this. Basically, the way I look at it is it's in two parts. One part is the necessary evil, the litigation side, the one where somebody, our clients, we only represent employers in the employment law world, we don't do plaintiffs' work, but our clients call us when they have been sued by a former employee, a current employee, for some sort of employment law issue. So we deal with the litigation side of things, proactive, trying to help people get out of them generally as cost effectively as possible. So the other side of my practice is the side that I prefer. It's the more proactive side. We call it the counseling side. So we do things like what I'm doing today. We try to educate employers, supervisors, HR professionals on how to comply with the very, very many employment laws that are out there. So we will do things like supervisory trainings, handbook reviews, policy preparation, wage hour audits, day-to-day kind of employment advice. If you have a question, hey, I want to hire this person, but I don't know what to do about an I-9, or I don't know if I should do this with regard to classifying them as salary, hourly, non-exempt, exempt. So we help employers make those decisions. And hopefully, if we're able to work on the proactive side, we get to avoid the litigation side, which is always my goal for my employment clients, because litigation is almost never any good news for the employer. So I was asked to come in and talk today about just very basic information about hiring and some of the HR-related issues that you all may encounter as you start and grow your companies. How many of you have employees already? Okay, just one. So you guys, once you get things ramped up, these are the kinds of the things that you will want to know. Knowing in the employment law world, a lot of what applies is governed by how many employees you have. So for example, if you have 50 or more employees, you're basically subject to every employment law you can think of, with a couple of limited exceptions. Do you have a question?
Yeah.
Yep.
What about what's considered freelancer employees from other countries?
As far as like contractors or employees, it depends on the situation. Now, and I'll talk about classification when we get to the wage hour portion, but that's a great question about whether somebody's an employee or a contractor. You can have somebody classified as a contractor if they're truly a contractor type position, meaning that what you really look at is how much control are you exerting over them. It doesn't matter if they're here in Florida, if they're here, across the pond internationally. It's how much control are you asserting over them as the either employer or the person who is under the contract. Are you telling them when they can work, how they can work, what hours they can work, that they can't work for anybody else? The more control you assert, the more it starts to look like an employee, irrespective of where the person is physically located. So that is a hot topic in the employment law world, and it's something that we see, messed up, if you will, on a pretty regular basis. The Department of Labor, which is the agency that governs a lot of the wage hour laws, they take the position that when somebody is misclassified, it's the employer trying to avoid paying employment taxes. So the benefit, if you will, to the employer is that they don't have to pay those taxes. Now, generally, I think people just make honest mistakes, and they don't mean to misclassify somebody. But the whole 1099 independent contractor thing is something that does definitely get construed in the wrong way.
A US company cannot really employ somebody in a foreign country without actual necessary visas or whatever permits or so on and so forth. So, but if somebody works actually in a foreign country and I'm exerting a lot of control over that person, what applies?
That's where it starts to look like an employment relationship, and when you really need to be careful about that. Number one, the employment relationship and whether somebody's properly classified. And number two, if they are an employee, then you have to deal with the immigration type issues that come up in that. But it really comes down to how much control are you asserting. Just the physical location itself really doesn't matter. If you are asserting too much control, then it may be a situation where you really can't have that person as a contractor. And I could see, issues coming up not only with the Department of Labor and the IRS for the tax purposes, but also with the immigration issue as well. somebody is, if you contract with somebody to perform some sort of service for you that they are performing for other companies and other people, and you're not trying to control, what they're doing, you hire them to do a job, and you pay them $1,000 to do this job for you, and they're doing that kind of job or something similar for, however many other companies, then that's going to generally be a contractor. It's when you have somebody who is, if they were located in Fort Myers, they would be sitting at your desk performing all of the work, and they're not working for anybody else. You don't want them working for anybody else. You don't want them doing the same thing that they're doing for you. That's when it starts to become problematic. So.
Would that apply to sometimes they have different sites where if my workload gets too heavy, you can hire VAs, virtual assistants.
Mm-hmm.
There's no way to really tell if they're working.
It's something like a virtual assistant is a company that you are contracting with generally that it employs the people that you're hiring as assistants. So that's a bit of a different circumstance where you are most likely contracting with, Virtual Assistant Inc.
Right.
And then they are supplying the people necessary to provide the service that you need. So if you're not contracting with, John Doe individually to be your virtual assistant, and rather you're contracting, like I said, with Virtual Assistant Inc., that's a different type of situation, and you should be totally fine there.
Gotcha.
Okay, yep.
What about as far as internship goes?
Internships is a very hot topic these days. As you can probably imagine, the law actually has changed relatively recently, but it's not settled. So when I say it changed, the previous rule as an employment lawyer on the employer side, I would basically advise clients don't ever have interns because you really need to be paying them if you have them as interns. Thankfully, the law seems to be changing to the employer side where the courts and the court where we are here in Florida, in Southwest Florida, is starting to look at who benefits from the arrangement. If it's somebody, for example, who's in school and they need to do an internship to get experience, then that's generally something you're going to be okay hiring an unpaid intern. You can always hire an intern and pay them minimum wage. And then you have no problems. Where you run into problems is where you're wanting to hire people and not pay them. That's when you want to dig deeper and start looking at what are they providing for you. If the intern is really displacing another employee, like you could hire somebody on to do that job, then that's where you start to get into trouble. If you're bringing the intern on primarily to give that person the benefit of experience and training, you're generally going to be safer, but it is a pretty rapidly developing area of the law. Like I said, it's starting to transition towards being more employer friendly, but it's still an area that is pretty hotly litigated. So it's a great question.
Thank you.
Okay, you're welcome. Anybody else? I mean, we will talk about this stuff too. I'll probably bounce around since we have a small group, and please do feel free to interrupt me if you have questions.
How about leasing?
Employee leasing is a whole other beast. When it's done well, it can work very effectively. Where you come into problems is with some of the PEO, the professional employment organizations or professional employer organizations. PEOs generally do like employee leasing, they do your HR, your work comp, all of that. You get into a joint employer situation where sometimes the employer, the actual employer, doesn't necessarily get the benefit of that relationship because the PEO can disclaim liability for a lot of things. Staffing agencies, just pure staffing, where you're not hiring out HR, they're not doing your payroll, all of that. Those can be a little bit cleaner, but what I always caution clients to do is make sure you know what company you're contracting with. Make sure it's a reputable company. Generally, the bigger fish are going to know what they're doing and what they can't do. But staffing can be, employee leasing can be a good way, especially for a smaller business, to get ramped up. But just know that it's not, I often have clients ask, well, am I completely insulated from this leased employee coming back and suing me? Not necessarily, because of that potential joint employment relationship. So it's not risk-free, if you will. Nothing in the law, especially the employment law, is really risk-free. It's a crazy world we live in, at least in my little employment nerd world. So, okay. I put this picture up there when I start these presentations. Most often I'm talking to HR professionals, and HR professionals are doing this on a daily basis because they are dealing with, they're babysitting, they're mommy and dadding people, they're dealing with significant issues in the workplace. And when I put this up and I say, how many of you feel like this when you're dealing with your employees? Every single hand in the room goes up. I kept it in here for this presentation, even though you guys are a different crowd, just because it's a foreshadowing of what you had to look forward to once you grow and start to have employees. And I'm mostly kidding. It's not all bad. But I will say, part of the reason that employment lawyers like me have jobs is because there are a ton of employment laws to be aware of, and there are a ton of them to comply with. And there are lots of very simple ways to unknowingly make mistakes. So I want to touch on a lot of the things that we see. I'm going to kind of speed through some of it because I want to make sure we have time to get through everything and answer questions. One thing that a lot of people don't know is you don't necessarily, to be sued by an employee or for somebody for an employment matter, it doesn't necessarily have to be a terminated employee. You can be sued by a current employee. You can actually be sued by somebody you never even hired if they can prove that you didn't hire them for some discriminatory purpose. The most awkward lawsuits that we deal with are the lawsuits brought by current employees. So you can imagine when we have to counsel clients about how to deal with an employee who's suing you, it really makes for some difficult interactions. So employers can be sued. It really is beneficial to make sure you have your employment practices in good order before you start hiring. So it's good for you guys to be here, listen to my spiel, and then you'll be aware of some of the things that you need to be thinking about going forward. So we're going to talk a little about interview questions. We'll talk some about documentation. We will focus a good bit on wage hour because wage hour is something that hits almost every business. So it's important to know. I will touch very briefly on discrimination, harassment, and retaliation just because they are very relevant topics in the employment law world. But like I said in the beginning, the laws, for the most part, whether they apply to a certain business depends on how many employees that business has. So discrimination, harassment, and retaliation generally don't come into play until you have at least 15 employees. I don't ever advise people to just act with impunity, like they don't have any kind of laws they have to comply with. But in theory, for example, let's say that I feel like my employer discriminated against me because I'm a female. If my employer has 7 employees, I am out of luck as far as wanting to bring a claim for that because my employer is not covered by these general discrimination and harassment laws. But it is important, so I'll just touch on it briefly. Okay, as far as hiring goes, you want to always keep your questions job related. When I mentioned a minute ago that applicants can sue you, people are very educated these days. You guys are all tech people, so you understand how much information is out there on the internet. There's employment law blogs on just about every topic you can think of. The workforce in general is more educated, so they know, what's okay and what's not okay generally in a workplace. I think that has been a significant factor that's led to an increase in employment law lawsuits that we have seen over the past, 5-10 years or so. You can't. Google is everybody's best friend. When I get on, actually, and as a lawyer even, I do a lot of research on Google. Everyone's like, what do you mean you research? You're a lawyer. You can't research on Google. Oh yeah, I can. Because there are other lawyers out there who are writing about this stuff. So I will type in sometimes, what do I do about an employee and medical leave? I mean, never that basic, but you know how you can see the prior search strings in Google. You can tell that employees are, can my employer refuse to pay me for seminars? And employment, the workforce is a lot more educated. So going back to hiring, make sure you're asking job-related questions only. You never want to ask about protected class information. We'll talk about what the variety of protected classes are at the end of the presentation. That's going to be gender, race, health issues, things like that. Financial background, including bankruptcy. This is a sensitive subject. There are some times when you can get into this kind of thing, but generally I recommend you stay away from them. If you have somebody, for example, who you're hiring as your money person, your CFO, your controller, your bookkeeper, whatever, their financial background may be more relevant than somebody that you're hiring to do, web development, something like that. You should never, ever, ever ask about health during the interview. You can only ask about health-related issues after you've made an offer to somebody, and even then it's a little bit complicated. Arrest and conviction records is a hot topic in my world these days, the EEOC. Employment lawyers and HR people talk in acronyms all the time. So if I say something and you're like, what the heck does that mean, Suzanne? Please stop me, because sometimes my brain gets going fast. So the EEOC is the Equal Employment Opportunity Commission. It is the federal agency that's charged with ferreting out discrimination, harassment, retaliation in the workplace. We have a state component here in Florida called the Florida Commission on Human Relations, the FCHR, another acronym. The EEOC a few years ago put out a guidance on what to do with arrests and conviction records in the workplace. And what the EEOC is saying is that you shouldn't have a blanket policy against hiring somebody with an arrest or conviction record. In the past, it seemed like just about every application I ever saw had a box on there, have you ever been arrested or convicted? If so, explain here. And a lot of employers would just refuse to hire anyone with any kind of arrest or conviction record. What the EEOC says you should do now is a targeted screening. So you want to keep in mind the kind of position that you're hiring and the kind of arrest or conviction that the individual has. So the example that I like to give, going back to the controller, the money person, if you do a background check on somebody, and by the way, there are permission forms that you have to get. So make sure once you start hiring, if you do decide to do background checks, make sure you're getting explicit permission from the applicants. But for example, if you're hiring for your money person, and that person happens to have a conviction for theft that's 5 years old, that's going to be related to the position that you're hiring for. And that's going to be a good reason, in my opinion, to not hire that person, because you don't want them dealing with your money. They have a past theft conviction. Now, if that person has a DUI 5 years ago, or a petty marijuana issue 5 years ago or 10 years ago, that's when you kind of get into this grayer area, or is that really related to the job that I'm hiring for? So that's the targeted screen right there. I guess the short answer that I want you to take from this is don't have a blanket policy against hiring somebody with an arrest or conviction. Always make your hiring decisions without regard to protected class information. So with the lawyers in the room, there's always a caveat, or it depends. There are certain circumstances where positions can require a certain gender or a certain background. They are very, very rare, and I would recommend that you don't hire I want a female under 30 for this position without getting counsel from a lawyer. So generally, make decisions without regard to protected class information. So when you start hiring people for your startups, what do you need? Generally, I-9s are the immigration forms. If you're hiring people here, generally everybody has to complete an I-9 form. I'm not an immigration lawyer. Lawyers have gotten much more specialized. I do the employment side, the harassment, discrimination, wage hour, non-compete side of things. We have an immigration lawyer who does nothing but immigration law. We have work comp lawyers who do nothing but work comp. So while I can tell you need to have I-9s, I can't tell you a whole heck of a lot about them, but I think Tulio may be speaking at one of these.
He will.
Okay,
With
so
yes.
if you're
Actually, next month.
Okay, perfect. Tulio Suarez is our immigration lawyer. He's board certified. He is phenomenal at what he does. And he can certainly help you with the I-9 process. He can help with the hiring of folks across the pond if you need to do that. But I can tell you that as part of hiring documentation, the I-9 is something that you certainly want to be aware of. Probationary period acknowledgement. This comes into play in the unemployment world. So most people know if you hire on an employee and that person gets terminated, generally, unless they've been terminated for gross misconduct or they've quit, they're going to be entitled to overtime pay. The probationary period acknowledgement is just a little acknowledgement form that you can have the employee sign within the first 7 days of employment that says, hey, employee, I recognize that if I get terminated during the probationary period, you, employer, will not be liable for my unemployment compensation. So it's not a huge deal, but it is something important to have because a lot of times, people find in the first 90 days, this person's just not working out. They may still get unemployment, it just wouldn't be charged to your business unemployment account. It's the way generally that unemployment works, employers pay into this account or system basically. And so when somebody is terminated, the unemployment benefits get charged to that account. So probationary period acknowledgement is good. Florida new hiring reporting, this is a website that the state of Florida has that supposedly requires each employer to report basic information about hires that they're making. If you just Google that, it'll come up. From what I understand, it's very simple to use, but it is something to know. Bonus question, what about work comp? At what point do you have to have workers' compensation insurance? Now, this varies by industry. Construction generally has to have it no matter how many employees. I don't think any of you are in the construction business or the physical part of construction. But generally, private employers, once they hit 4 employees, they have to have work comp insurance. And there can be significant consequences if you don't. So once you guys start hiring, just be mindful of the fact that once you hit that 4 employee threshold, you need to look into work comp. Yep.
What kind of documentation would you need, or forms do you have to fill out if you're offering stock to an early employee as a part of the employee connection?
That is something that would be better asked to our corporate attorney, who will also be here, I think Guy Weitzman, in a couple of months. But generally, you will want to put together with an attorney stock purchase agreements.
Okay.
They are pretty complicated, or they can be pretty complicated, because you want to make sure that you're thinking about what happens if the relationship goes wrong, and how do I get this person out, and things like that. So Guy Weitzman, who is the head of our corporate department, will be here in a couple months, and he will be talking about that among other things. How to incorporate what corporate structure is the best for you. So that's definitely a good thing to think about. And I know for startups, that's often how you bring people in, as a promise of equity. So you can certainly have one agreement that you have put together that you massage to use for each person that you bring on. Yep.
I don't know if this question's out of topic, but what about healthcare with the?
Yep. The good thing about the Affordable Care Act, which is what everybody thinks of as Obamacare, the Affordable Care Act only applies to employers with 50 or more employees. So smaller companies are not legally required at this point to offer health care to their employees. Once you get to that 50 employee threshold, you are required to follow the Affordable Care Act. So for a while, you guys should be good on that. You can choose to contribute if you want to, and there are certainly exchanges that small businesses can join into, and actually one of the benefits about PEOs is that PEOs can offer insurance, group insurance with the PEO technically is the employer of all of these employees, whether they're on your location or somebody else's. So they have pricing power basically. They can go in and get discounted health insurance for smaller companies. But as far as legal obligations go, not till you hit 50. Okay, what about employee handbooks? Employee handbooks are great once you have employees in your company. There is no law that requires a specific handbook or that requires specific things to be in a handbook, at least for a smaller company. The things that I like to see once you do get started and you do have employees, I always like to see timekeeping policies, because I find that the most dangerous laws, especially for small businesses, are going to be the wage hour laws, the Fair Labor Standards Act, which is the FLSA, and then we have the Florida Minimum Wage Act as well. But I like to see timekeeping policies, and we'll talk about, briefly about exempt and non-exempt and what all of that means in the wage hour world. But timekeeping policies that tell non-exempt employees how they have to track their time. Yep.
Yeah, I was just gonna say, a lot of what I do is on retainer, and it's more of a by project type of thing. Does that still fall into, like, if somebody's doing hourly work for you, or is it just all covered under the monthly retainer?
It depends. If they're actually an employee of your company, then you can pay somebody on a retainer, but you still have to track their time, because you still have to make sure that they're making at least minimum wage, and if they're working more than 40 hours in a work week, that they're being paid time and a half overtime.
Gotcha.
The only exception to that would be for an employee as opposed to a contractor, would be if you have somebody who is an exempt employee, like a management employee or some somebody who is making significant decisions for the company, that person may be exempt, and then you could pay them on a salary instead of a retainer, but a salary basis. But generally, for non-exempt employees, you can do the retainer, but make sure you're still tracking the time, make sure they're being paid at least minimum wage, and make sure if they're working overtime that they're paid. Handbooks, timekeeping policies, you want to have an acknowledgement in there where the employee just says, hey, I received and reviewed this, and I agree to abide by it. And you stick that in every employee's personnel file. Once you get bigger and you have, you can have what's called an EEO policy, Equal Employment Opportunity Policy. You can have that at any size. Certainly once you get to 15, you want to have that in your policy handbook. Basically that just says, my company doesn't discriminate based on the long list of protected classes that I'll go over briefly. So those are some of the things that I like to see in employee handbooks. I do think that they're important, especially as you grow, because it gives you as the employer the opportunity to look back and say, hey, here's my policy on this, and here's what you need to do to comply, or you weren't complying, so I'm going to discipline you, or I'm going to terminate you. But they can really, really be helpful, I think, for employers. Performance management. So this is management of your employees once you hire them. Any employment defense lawyer, you will hear talk about documentation all the time. And I will tell you on the next slide, I think. I don't know why that thing is there. It's a silly little circle. Any defense lawyer will tell you employment documentation is so important because what happens is what we love to call the halo effect. So the halo effect is when one of my clients comes to me and says, I just received this demand letter or this lawsuit from John Doe, and John Doe was the worst employee ever. He never came to work on time. He was totally insubordinate. He had an attitude, all this laundry list of complaints. So I fired him. And so I say, great, show me his personnel file. And so I get the personnel file. John Doe looks like the model employee because his evaluations all say, John Doe is doing an excellent job. John Doe is doing a satisfactory job. There's no record of discipline, no record of poor evaluations. So you can imagine from the defense lawyer's perspective, that makes things challenging to prove that John Doe really was such a bad employee. So that's really gotta get that out of there. That's really the halo effect. So John Doe is the worst employee ever. So be careful about that. Evaluations, I won't talk much about this because you guys aren't HR or direct supervisors yet, but evaluations are important even for small companies. And they're not only important from a lawyer standpoint, they're important for you as a business owner to make sure your employees know what the expectations are. You want to make sure your employees know what they're doing well at and what they're not doing so well at, so they can improve. And the benefit for the employment lawyer in the room is that you now have record of some of the performance issues. So evaluations are not only a benefit from a lawsuit perspective, but they really do help you manage your employees and help them grow and help them be the most productive employees that they can. Now I know I always hate to be a hypocrite, but we have to evaluate our staff every year. And it's sometimes hard, to give somebody a candid evaluation, somebody who I like, somebody that I've worked with for a long time. It can be challenging to sit down and say, hey, Sally, here are where I see your areas for improvement. But it really, truly is important, again, not only for the documentation in the file, but also so Sally can understand where her performance is lacking.
Sorry, go ahead.
How often do you recommend a performance evaluation?
I don't remember if I still have a cartoon in here, but at least annually.
Okay.
It's good to have an evaluation at the end of the probationary period, so the end of that initial 90 days, so you can decide, is this person working out? And if you are going to keep them on, you can let them know, hey, here's what went well your first 90 days. Here's some goals I want to set for you going forward. So I think definitely at the end of 90 days and at least annually. Some businesses do them more often. Most, I would say, do them annually. Peter, did you have another question?
Yes, regarding qualitative and quantitative performance measures, and obviously quantitative is the best, but salespeople, it's easy because this is the number, we didn't reach it, whatever. But there are many positions which is more qualitative.
Yeah.
So what about that?
Yeah, and that's a great point. When you have quantitative measures you can point to, that's easy. You have a sales quota, you either met it or you didn't. So here's your performance in that respect. But the qualitative are equally important, because that's gonna be things like attitude. It's gonna be things like initiative and discretion and things
But
that
how do
really.
you measure those? It's more of that, because
is.
it's a very subjective term.
It
I
is.
think your attitude sucks. you
Yeah,
know?
it
And then he
absolutely
said,
is.
no, it doesn't.
It
So-
absolutely is, and there's no way to quantify something like that. The way that evaluations generally work, and businesses can set them up however they want to, but generally you'll have some sort of scale that says, unsatisfactory, good, excellent, excel.
But in case of a dispute, especially
Mm-hmm.
legal dispute,
Yep,
I mean, what is the weight of these things when an employer says, look, you subjectively,
right,
your attitude is not okay, and
Sure.
then the employee said,
Mhm.
no, it was fine.
right. Well, where that comes into play and where the best defense is gonna be made is if you have somebody who's evaluating multiple people, so you can see how they evaluate everybody, and if they are being consistent without regard to protected classes,
Mm.
complaints, things like that.
Mm.
When you have a broad base to draw from, that's the comparison that you use. If it's just one in a vacuum, then it is more challenging to say, well, this is the supervisor's proper evaluation of it. But from a defense perspective, we will look at, was this supervisor properly or fairly evaluating everybody the same, And every lawsuit comes down to who a jury believes is more credible, if it gets there. So you're gonna have, one of my favorite mediators says, when you think about a jury trial, think about going into 7-Eleven, pick the first 6 people that you see, and that's your jury. So you can literally never predict what a jury is going to do. But it all comes down to who's more believable. And if there's one employee who's saying, my supervisor was unfair, but you have a supervisor who supervises 3 or 4 people, and they consistently evaluate everybody, it doesn't mean they give them the same marks, but their processes are similar, then I think the employer's gonna have the better standard there. One line of cases that I love as a defense lawyer is this line of cases that says, it's not unlawful for a boss to be a jerk, essentially is what these courts say. What can't happen is your boss can't discriminate against you because of your protected class. Your boss can be a jerk. I mean, it's not unlawful to be a jerk.
As long as it's consistent.
As long as you're consistent, yes, we call them equal opportunity offenders.
Yeah.
So as long as you are an equal opportunity offender, then I'm okay with it in the employment law defense world. So it's the consistency that's key. So, very good question. Okay, yes, to your question. Your annual review is happening sometime in the next few years. This is my advice, don't do this. Do it at least annually. Okay, discipline. This is something that also can be a challenge, but what I recommend generally is once you get large enough to have employees, you want to have what we call a progressive disciplinary policy. You can structure it however you want. But this is a policy that we see pretty often, progressing through steps of discipline, verbal, written, suspension, termination. You guys have probably seen similar things in employment that you've had. I often get asked, does that mean I have to go through this process? If I have a really bad employee, can I just terminate them, or do I have to go through this process? There are definitely some offenses, if you will, or some performance issues that warrant moving to some of the higher levels of discipline quicker than some others. It just depends on the severity. It depends on the consequences of the person's behavior or actions. So it really is a case-by-case basis, but this is a good guideline, not only for you, but for your employees, to have this progressive disciplinary policy.
Would it cause problems in the event that you were moving through them at different rates for different employees?
If there were similar offenses, it definitely could. So for example, if you had somebody, let's say you have an attendance policy, and 3 tardies and you get a written warning, or 3 tardies and you get a suspension, and your female employee gets accelerated discipline and your male employee doesn't, that could be a problem.
Or the contrary, where the girls can get away with it?
Exactly. I always have to use the girls. So yeah, but as long as there's similar offenses, then you should enact the same discipline. But if somebody has a different history, for example, let's say that Susie's already at the written warning level and Joe is never had any discipline, then Joe, for his next absence gets the written warning and Susie gets a suspension. So, consistency again is gonna be key. Document this, yes, of course. Always document what you're doing.
Regarding documentation, I mean, we are in the digital age,
Sure.
so does it need to be on an actual file, paper, or that, or can it be all digitally
It can
recorded?
be all digital, yeah, absolutely. Even the snail lawyers are moving towards digital files these days.
No.
I know, it's crazy. I will say.
Don't
it is-
scare us.
I know, it is really nice though, because I can just carry this around. And I
Yes.
can go home and I can literally pull up my entire desktop from my
Yeah.
house. When we first started doing this, it was like, ah. Our firm it's a wonderful firm, but we've been around since the 1920s. So you can imagine a little bit of a snail pace at trying to adapt the technology. But even lawyers are getting on board with electronic filing. But I actually have a lot of clients who keep all of their personnel files online. Now, one thing you do need to be mindful of once you start hiring people, you need to have separate files like for medical information. So if you have an employee who brings you a doctor's note or has some sort of disability issue, make sure that that's kept in a separate file, not with their evaluations and disciplinary actions and things
So
like that.
it's digitally, it should look
Yeah.
like physically.
Absolutely.
Okay.
Yeah, it shouldn't just be one, thing that you can scroll through. I'm sure there are technical terms to describe that. But yeah, different files if you can, where you have a medical file, just like you would have a folder in a
Mhm. Yeah,
personnel
so for
file.
different folders, yeah.
Well, the safety aspect of that, I mean, you're putting everybody's information so easily on a computer and your information just tapping into it,
Sure.
instead of going to a file-based system.
Yeah.
You're putting that out there, if it's not encrypted or not,
Well, that's what we recommend. You definitely should do it through a software program that's, designed for that. And there are so many companies that provide that these days for online management of personnel files that I think as long as you're using one of those and you're not, making your own unsecured system, I think you would probably be okay. But that's definitely a consideration. And of course for us too, we put all our client stuff online, but we have all sorts of different webs and protection and things. And, sometimes people get hacked anyway, but, definitely have a software program that's designed to protect that information.
NSA got recently hacked.
Oh, sorry?
The NSA just got recently
Yeah.
hacked on some tools.
Yeah, it's crazy when you get these government agencies that are responsible for
What's
these
ironic
sorts of
is
things.
that their hacking tools to hack to us got hacked.
That is crazy. I have another lovely bit of irony for a government agency. Yesterday, there was a story published that the Department of Labor, who again is the agency that is responsible for knocking on employer doors and saying you're not paying your employees right, is going to pay $7 million in back wages for not paying people
Oh
right.
my gosh.
Yeah,
What a
so
hypocrisy, my gosh.
Yeah. I think, to me, that just illustrates how difficult it is to comply with the wage hour laws, and it really truly is. But the Department of Labor has agreed to pay $7 million in back wages. Okay, let's move to termination. So I have had, and actually this has happened to me a couple times just in the last month. I've had clients come to me and say, I fired this person, but I didn't tell them why. That can be really dangerous because if you don't tell them, I get the question all the time, well, Florida's at-will employment, which generally means you can fire somebody for any reason or no reason, as long as it's not based on a protected class or in retaliation for something. But I always say, no, it doesn't necessarily mean that. If the employee isn't given a reason, the employee will make it up or his or her attorney will. And I have actually seen real lawsuits happen because the employee wasn't given a reason for termination, even when the employer had a really good one. So I always caution clients, especially when you have a good reason to terminate somebody, sit them down and tell them why you're terminating them. If you can, have a witness present with you, so it's never just a he said, she said, or he said. But the best terminations are well documented, the employee is told why, and you have a witness present. So I strongly caution against the whole, I'm not gonna give you a reason for your termination.
What
Yes.
kind of documentation would be substantial or?
Nothing, it doesn't have to be anything fancy, I'm sorry.
Like a termination letter?
It can be a letter, it doesn't even have to go out to the employee if you don't want it to. Just something that you guys can put in your files to document, I decided to terminate John Doe because of XYZ. Here's what I had tried to do with him in the past. I tried to give him a performance improvement plan, or I suspended him and told him if he did it again, I would terminate him, things like that. But nothing special. You can absolutely create your own forms. There's a lot of HR companies that will provide them for you. You can buy them at Office Depot. But just some sort of documentation that says, so you can look back if you get sued a year later and say, no, here's why I terminated him. Okay, yep.
So I will well document it, but I will say it in the documentation that I don't like this person, and I'm the one paying that person, so I just don't like it.
Right,
Several times I don't like the person, so I hire the person.
right. I mean, as long as you don't not like them because of some protected class, you
No,
are
no,
okay.
it's not,
Yeah.
yeah, I understand, it's
Yeah.
not protected,
No.
it's general.
Yeah, absolutely. If you don't get along with them, or you don't like the way they talk to your customers, then yeah, absolutely, you don't like them. Yes.
Another side of the coin, if, for example, I was terminated because the company was downsizing, it's not the fault of my own.
Yep.
But the company's bottom line is
Sure,
hurt.
sure.
Do I have a right to request something documented, I was released because of
Yeah.
this? That way it was not gonna hang me up with your future
Sure.
employment?
Yeah, you can certainly request it. They're not legally required to provide it to you, but in those circumstances, I would say most employers will provide it, or they will let you know that if they receive calls for references, they will let the potential employer know that it was a layoff due to downsizing and not a performance issue. So yeah, you can absolutely request it. Whether they give it or not is up to them. All right, I already said this. Make sure your documentation is in order. Have a witness present if you can. Okay, wage and hour. Why do we care about wage and hour so much? We care because the damages for potential employers are very, very significant. And also because the FLSA is one of the laws that applies to almost every business, unlike, the Title VII discrimination laws where it's based on your size. The FLSA applies, I'll talk about the two kinds. Enterprise coverage is what's looked at as the business coverage. So what we look at there is, does your business gross at least $500,000 a year? If it does, then you are covered and all of your employees are covered. Even if you don't gross $500 a year, individual employees can still be covered under what's called individual coverage, creatively. And what that looks at is whether the legal lingo is, are they moving or are they acting with instrumentalities of commerce? So that means, are they using equipment that has traveled across state lines? Did you buy a computer, that was manufactured in Georgia and sent to you? Are you using credit card machines where, the credit card company is based in Delaware or wherever they are? So individual coverage is very broad. So what I generally advise employers, even small businesses, is, you really should check into whether if you're under 500, if you're over 500, then it's not even a thought anymore. If you're under 500, you should still assume that your employees are covered unless they are, a lot of times with blue collar workers, with manual labor, they're not using equipment, they're not using credit cards, but the majority of individuals will be covered one way or the other under the FLSA. So that's why we care as employers about the wage hour laws, because number one, it almost applies to everybody. Number two, the consequences for employers for violations can be very significant. So you can have the Department of Labor knock on your door, like I said, and they'll want to go through all your records, they'll want to talk to your employees, and then they'll come back and they'll say, hey, I think you did XYZ wrong, and here's how much I think you owe. Even if the Department of Labor is not coming to do that, you can of course have somebody sue you. You probably, if you're based in Southwest Florida, you hear Morgan & Morgan advertise all the time about, have you been paid your overtime wages? You probably won't be surprised to hear that the majority of the wage hour lawsuits we see are Morgan & Morgan lawyers. They are very active in this area, and I think it's because the damages can be significant. And what I mean by that is, let's say that you accidentally messed something up. You didn't pay somebody overtime, or you had somebody misclassified and you were paying them a salary when they really should have been paid hourly with overtime. And they are owed $1,000 in back wages. So you potentially are on the hook for the $1,000 to the employee in back wages. They have this thing called liquidated damages, which is double damages, which is almost assumed in every case. Unless you got bad advice from a lawyer who said you were doing it right and you were doing it wrong, or unless the Department of Labor said you were doing it right and you were doing it wrong. Basically, every employer has to pay liquidated damages. So now you've got the $1,000 in back wages, the double damages, so $2,000 in back wages. What really drives it is the plaintiff's attorney's fees. So you're having to pay the plaintiff's attorney's fees and you're having to pay your own lawyer. So as you can imagine, I literally, when I have a client come in to me for the first time for a wage hour lawsuit, I say, I have a Grim Reaper speech, and I really do. Like, there is no good news for an employer in a wage hour lawsuit. So it's so important to know these laws and to make sure that you're doing your best to comply with them.
And that's only relevant to companies grossing over 500,000?
Yes, unless you're individual. If you're under 500 and you still have employees that are, running credit cards or using equipment that has been purchased from out of state, then they could still be covered even if you don't gross 500.
Oh, okay.
So that's how it kind of gets to everybody, because most employees, even if the business doesn't gross 500, most of them are going to be covered one way or the other. So that's how they pull you in. And even if the FLSA doesn't apply, you still have to contend with the Florida Minimum Wage Act, which does apply to everybody. Now, the Florida Minimum Wage Act does not have an overtime component. It's just the federal law that has an overtime component. So yeah, I basically advise clients just assume you're covered and try to comply. If you have a situation where you want to know if you're covered or if an individual employee is covered, then you'll certainly want to ask a lawyer to make a determination for you. And again, like I said, if we give you bad advice and you rely on it, you can potentially have a defense to the liquidated damages part. So that's always good. Except, of course, we never give the wrong advice. But okay, back to exempt, non-exempt. This is probably the first determination you need to make when you hire somebody. So people generally think exempt versus non-exempt means salary versus hourly. It's not that simple, because in theory, you could have a non-exempt person who's paid on a salary. You can have an exempt person who's paid by the hour. So it's really not that simple. The legal definition is non-exempt means you are not exempt from overtime laws. So if you're non-exempt, you have to be paid at least minimum wage, and you have to be paid overtime if you work 40 or more hours in a work week. And I underlined work week because work week is a 7-day period, the same 7-day period every week. So for example, let's say you guys hire on employees and you want to pay bi-weekly, so you pay every other week. That's totally fine. But if you have non-exempt employees who are potentially working more than 40 hours a week, you have to take that paycheck and divide it into a work week. So you want to look at, it doesn't matter what the day period is. It can be Sunday to Saturday, whatever your 7-day period is, the same period every week, and you look at that 7-day period to see, has this person worked more than 40 hours a week? What we often see pop up is when somebody pays, every 2 weeks, they'll look at 80 hours. And so if the employee works 45 in the first week and 35 in the second week, they think, oh, I'm good, I don't have to pay overtime, but that's not true. You have to pay the 5 hours of overtime to a non-exempt employee in that 7-day period. So that's non-exempt. Exempt, if somebody meets one of the defined exemptions, then he or she is exempt actually from both overtime and minimum wage. So that means if you have somebody who's exempt, you can pay them a salary and you don't have to track their time, and they're not entitled to overtime if they work more than 40. The exemption it can be a difficult gray area. So we'll talk about some of the common ones.
So just for the non-exempt, so if somebody is non-exempt but paid a salary, so a salary non-exempt, still overtime needs to be paid.
Absolutely, yeah. And so that's why we generally don't advise you have a salary non-exempt person, because it removes the benefit for the employer, because you're still having to track their time and you're still having to pay overtime based on how many hours they're working. Now, you can have a situation where you make an agreement with an employee that they're going to receive a certain salary for a certain number of hours, and as long as they know, and as long as that's enough to be at least minimum wage plus time and a half for the number of hours you agreed to, that's okay. But you still have to pay the overtime if they go over that agreement. So I generally caution against salary non-exempt. I think it's just cleaner to have non-exempt employees paid on an hourly basis. Okay, so what does somebody have to do to meet an exemption? There's 2 tests, the duties test and the salary basis test. Now, if you've heard about the overtime changes that are coming December 1st, They are all focused on this second component, the second test, the salary basis test. Because the minimum level that I have right here, it currently is $455 a week. It's now, as of December 1st, gonna be $913 a week. So that means that if you have an employee who is exempt, and the next slide talks about kind of what the exemptions are. After December 1st, that employee has to make, at least $913 a week, which comes out to $47,600 per year. So that's a very big change, as you can imagine. So we have a lot of clients who have employees who kind of hover in between this $25,000 to $45,000 a year threshold. And our clients are going to have to decide what to do with those folks. Are they going to bump them up so they make over 47, or are they going to change them to hourly? So these are considerations that you want to make sure you're aware of once you start hiring people. The common exemptions, executive, administrative, professional are the top three that we see. Executive is going to be your management exemption. So if you have somebody who is managing 2 or 3 people, 2 or more people, at least 2 people, and also who's hiring, firing, making scheduling decisions, things like that, then that person generally is going to be exempt if they meet the salary basis level. Administrative is going to be somebody who is performing like office non-manual work, but who is given a significant amount of discretion within their little world, whether it's a department or a unit. The example I always give is HR professionals. HR professionals generally are exempt under the administrative exemption, if not under the executive exemption if they have multiple employees. Also, marketing people can be exempt under the administrative exemption if they are given enough decision-making authority to, call the shots on what's happening in their world. The professional exemption is going to be lawyers, doctors, engineers, people with advanced degrees. There's also a creative professional exemption that may come into play for some of you. That can be sometimes designers can be exempt under that. So that's one you may want to look at. But again, always remember that they're going to have to meet that minimum salary level. And that salary level is going up in December. So be careful about that. Outside sales, if you have somebody, the classic door-to-door salesman, generally, if they're spending the majority of their time out in the field selling, they're generally going to be exempt from overtime. And then computer professional, it doesn't pop up very often, but it's somebody who's not necessarily responsible for like end user support or troubleshooting. It's going to be your systems engineers, your software development type folks. They can be exempt under that computer professional. Now, we call them the EAP, the first 3. Those are the 3 where the salary level is going up. So outside sales, there's actually no minimum salary. And then computer professional, they have their own system. It's like $27 and something an hour that they have to make. So common problems that we see. Let me get these all up, just so you have an idea. And I could talk for hours on all of these, thankfully, for your sake. I don't have that much time, but just to give you an idea of some of the things you should be thinking about as you start to hire people. Misclassification, I've already touched on. Now that can be misclassifying somebody as exempt or non-exempt. It can also be misclassifying somebody as a contractor, which is what we talked about in the very beginning. So be very careful about that. Improper deductions, if you have an exempt employee, they should be making the same salary every single week, almost without exception if they're working that week. So for the example that I like to give, if you have your manager, let's just say you get big, you have a manager who's managing people, and this person needs to take half a day off to take their kid to soccer or something. You still have to pay them the same salary because you can never take a partial day deduction from an exempt employee's pay. You can take full day deductions in limited circumstances that I won't get into now. But just be aware that if you do have somebody that you're paying as an exempt salary individual, they generally should be paid the same salary every single week. Off the clock work is a big deal. Pre-shift and post-shift, at what time does the employee actually start performing work? You can have a schedule, 8 to 5, 9 to 5, whatever the case may be. But if that employee gets there at 8:30 and they start working, they need to be on the clock. Now, you can prohibit them from doing that. You can say, hey, Sally, you're not allowed to start working until 9 o'clock, but you should make sure that Sally's not performing work before 9, if that's the case. So you've got to be really careful about this off the clock work. Is everybody excited about hiring people now? Yeah. Travel time, the ordinary commute from home to work and work to home at night generally is not gonna be paid time. The exception to that is if you have employees who are, talking on their cell phones or whatever during the commute for business purposes, or picking up, they have to go to the store and pick something up and then come to the work, pick up something for work, and then come to the office, then that's when the clock starts rolling. Electronic devices are a big deal these days because, no one can get away from their smartphone. We all have them in the middle of the night, you're looking at them and responding to emails, or at least I am. So if you have non-exempt employees who have company phones or who are responding to company emails, that can be problematic. So be very careful about that. Breaks. A lot of people think that, people have different impressions about breaks. There is not currently a law that mandates employers give breaks unless somebody is a minor. So you are not legally obligated to provide breaks. However, most employers do. And if you're going to provide breaks, generally breaks of 20 minutes or less are going to be paid time. So people generally shouldn't be clocking out for those short breaks. Meal periods, if you want to have a lunch deduction, they have to be at least 30 minutes where the employee is not performing any work. So the thing that I always tell people to think about is that person performing work for the company? If the answer is yes, they need to be on the clock. And I'm talking about non-exempt employees, because for truly exempt people, you can require them to work 80 hours if you want, and they don't get paid anything different than that salary. Timekeeping is important. You want to have, once you have employees, you want to make sure you have some kind of timekeeping system. I kind of joke that I don't care where you do it, you can write it on a napkin. I really would prefer you don't write it on a napkin, but there's no law that says you have to have a punch card or, a crazy iris scanner or anything like that, as long as you have some system for employees to track their time. I think the best systems are where the employees are doing it themselves, as opposed to a supervisor doing it, or as opposed to just going off of a schedule. But again, you have the flexibility to do it however you want. But I think from a defense perspective, the time cards that I like to see are the ones where the employee is tracking his or her own time. And the best timesheets that I like to see are the ones where they will say, there's a disclaimer on the end that says, I certify that I properly reported all the hours that I worked this work week. So that's really helpful for me as a defense lawyer. If I have 52 of these timesheets where the employee is saying, hey, I only worked, these hours and I sign off on it. And then when they come back later and they say, oh, I was working all these extra hours, I can go through one by one and say, why did you sign? It is helpful. Not legally required, but helpful, yes.
So you have a system where people log in, you can track their time. It's great. The system goes down and then they're kind of on the honor system.
Yeah.
How do you?
If the system goes down, I would have them write it down on paper, and as soon as it comes back up, go and input it in. So, or send it to you in an email or whatever. Hey, I left work at 5:05 p.m. today. Or write it down anywhere. As long as you can then take it and put it back into the timekeeping system, it doesn't matter what format it's in, as long as somebody, preferably the employee, is keeping track of the time.
Can it be a little, I want to know, were you on the phones, making your calls? Any record of that?
Yeah, you can absolutely, you can try to verify that they were actually working. Now, can you prove it? I don't know. What I always say to people is if you're ever in doubt about time being worked, as an employer, you should just pay it. Because you will save so much money in the long run by just paying that 15 minutes that the person said that they worked than you will by having to go through a lawsuit. What you can do as an employer is you can have policies against, for example, overtime. A lot of companies have policies that say you can't work overtime unless it's approved by your manager. That's perfectly appropriate. You can absolutely do that. Or a policy like I mentioned, don't start working before your scheduled start time. Perfectly acceptable. However, if the employee works the overtime unapproved, or if the employee clocks in early and starts working, you should go ahead and pay them, but what you should do is discipline them for violating the policy. And you can discipline them up to and including termination if they continually violate it, because that's the benefit of having the policy, is saying, hey, you know you're not supposed to work overtime without permission, but if they do, you should go ahead and pay it and then discipline them for it. That's the best way to handle it, in my opinion. I I'm leaving work to go home and check work email. Who does this? I do this all the time. I just put it up there because I think it's funny, but it does illustrate some of the problems employers are running into now with smartphones. Okay, record keeping, and I'm going to breeze through some of this stuff because I don't want to keep you too long. The FLSA does have very specific record keeping requirements for employers. So once you have a physical location, make sure that you have a poster up. The Department of Labor has all of these things on its website. So there's a minimum wage poster. There's actually what's called an Employee Polygraph Protection Act poster. I have never seen that come into play in the real world, but basically what it means is unless you are law enforcement, you can't subject your employees to polygraph tests. So in case you were wondering, do not polygraph your employees. But there is a poster for that.
I just wanted to do that.
I know, right? You can't do it unless you're law enforcement.
Have to return the equipment.
That's right.
Yeah, so don't polygraph anybody and put your poster up. So these are some of the records you need to keep for your non-exempt employees. You should keep them for at least 3 years because the maximum statute of limitations under the Fair Labor Standards Act is 3 years. Actually, if you want to be super duper safe, you should keep them for 5 years because the Florida Minimum Wage Act actually allows employees to go back potentially 5 years. So if you want to be super safe, if you've got everything electronically, then it's kind of a non-issue. But keep for a minimum of 3 years, you want to keep this on your non-exempt employees.
What about drug screening?
You can absolutely do drug screening.
Can you do it mandatory if
You can
your
do,
clients need it, so the company needs
yeah,
to be
you can
aware?
do pre-hire employment drug screening. You can do reasonable suspicion testing if you think somebody's showing to work under the influence. You can do post-accident testing, and once you have work comp insurance, you'll be required to do that. But yeah, you can absolutely do it. I recommend you have a policy notifying employees that they'll be subjected to it. But yeah, you can definitely do the drug testing. Yes.
What's the law on that from, I don't know, I guess it would be from the clients, and like, for example, one of the old agencies I was working at, we were doing some work for the sheriff's department, and they wanted the company to screen all of the employees at our agency. Are they,
Sure.
is that allowed? Are they
Yeah.
allowed to do that? Okay.
Yeah, it absolutely is. And that'll come into play a lot of times when people are contracting with schools and things like that. You have to do thorough background checks, you have to do drug tests. But if generally there's gonna be a law that requires that.
Right.
So yeah, it is absolutely okay. There's nothing unlawful about drug screening. So I like to see permission given for it and notice given. But I would say probably the majority of my clients have drug testing policies. Okay, the DOL final rule, I already mentioned this briefly. I'm not going to go over it in detail, but this is the change to that. Remember, there's 2 parts to the exempt test, the duties test and the salary basis test. So the salary test is what's changing as of December 1st. That's going from, again, $455 a week to $913 a week. So if you have an exempt employee, your manager, or whatever the case may be, to keep them properly exempt after December 1st, you've got to pay them at least $913 per week. There are, you can use some non-discretionary bonuses for that, but that gets into more complicated payroll type issues. Just the basics to take away, after December 1st, the salary basis jumps up to more than double. So keep that in mind. I can make this PowerPoint, whoops, that was really fast. What can you do if you have an employee who's, making 45 and you need to make 47, you just pay them the extra 2. Or you can do calculations where you're coming up with the overtime rate based on how many hours they're working. So you take their salary, you're welcome to take, let me make sure I've got everything, there we go. You're welcome to take photos of this if you want to. Come up with an hourly rate if they're not going to meet this $47,000 threshold and they need to then be paid as a non-exempt employee. So you want to start them tracking their time so you can figure out, is Sally working 50 hours a week or is she working 60 hours a week? And then you can run this cost neutral option. So let's say Sally was making $800 a week before, and now Sally's not going to be making enough because the new threshold is $913. Well, you can divide that $800 a week by the number of hours she's working to come up with a cost neutral rate. So she's still making the same, you're still paying the same, and it's not as much of a change for everybody. But December 1st is the date to know for that. It's a part-time position, 10 hours a week with 30 hours of unpaid overtime. Don't do this. So that's not a good resolution. I have been asked several times about part-time, can I hire more employees to avoid having to pay somebody this $47,000 a year? Yes, you can, but be mindful of employee counts. Like I said, the number of employees you have generally determines what laws you're subject to. So the example I always give is once you get bigger, if you're hovering at 48, 49 employees, don't hire a bunch of part-time people because those are going to count towards your full-time equivalent. And once you hit 50, you're now subject to the Affordable Care Act, which is Obamacare, and the Family Medical Leave Act. So just always be mindful of your employee counts. Okay, we completely disregard gender when offering compensation, unless you're the wrong gender. So that's my transition into a very, very quick discussion of discrimination, harassment, and retaliation. So discrimination from a legal perspective, this is what we look at. Is somebody a member of a protected class? Did the employer take an adverse action against them because of that protected class? And did the employer treat similarly situated employees differently from that particular employee? Adverse employment action, the most obvious one is termination. Everybody knows that. You can't fire somebody because of the color of their skin or because of their gender. But it also includes anything that basically affects the employment, a tangible employment benefit or detriment. So keep that in mind. Discrimination is prohibited in all aspects. I talked about hiring. You can't discriminate in your hiring once you get big enough to be subject to these laws. Now again, I don't recommend anybody discriminate no matter what their size is, but once you're subject to the laws, there can be significant legal consequences. So it's not just termination, again, it's recruiting, interviewing, et cetera, et cetera. Handbooks will generally have a policy that says we don't tolerate discrimination or harassment on the basis of, can anybody give me some examples? I've already talked about a couple of them. I can stump people on religion. Good, yes, religion. I talked about gender. We've got race, color. Anyone think of more?
Familial status.
Family status, that's a good one. All right, since we're running out of time, I'll spare you the quiz. National origin, gender, pregnancy, religion, disability, marital status, veteran status, genetic information. I get to genetic information and everyone's like, huh, what's genetic information? So genetic information is the newest of the discrimination laws, and it's actually about 8 years old now. Genetic information is literally what it sounds like, your genetic information. Why employers care is because the way the law is written, it includes family medical history. So the example that I always give is, let's say you're doing a Facebook screen of an applicant, which can be dangerous, so be careful about that. But I won't tell you not to do it, because everybody Googles everybody these days. So you're Googling your potential applicant, and you see that Sally is a member of a breast cancer survivors group, and her mother had breast cancer. Breast cancer is a genetic disease. So you can't then not hire Sally because you're afraid she's going to get breast cancer. That's family medical history. There are very, very few cases of these moving through the court system, but they are out there, so it's something to be aware of. Sexual orientation is a hot topic, as you can imagine. It's actually not currently protected under Florida or federal law. I suspect that's going to change very soon. But right now, sexual orientation and gender identity are not protected under Florida or federal law. The EEOC, that agency that I've been talking about, is trying to fit these claims in under gender discrimination, and they're having some bit of success with them. So even though it's not legally protected yet, I'm still advising clients, you want to consider that a protected class. So. EEOC cases, I won't get into that one. Just know that the EEOC is pushing them through even in Florida on sexual harassment. Anyone know what the magic number is for federal age discrimination? When I first started doing these presentations, it sounded a lot farther away than it does now.
50?
40.
40. Wow.
40. So yeah, I don't know about you guys. 40 doesn't sound so old anymore. But under the federal law, technically 40 is the age limit for discrimination. The state law, Florida, actually doesn't have an age requirement. So in theory, you could discriminate against somebody because they're too young. I have not seen that.
I'm a protected
But
class.
yes,
Yeah.
yes, we are all protected. Disability is something we see a lot in the workplace these days. So a disability, the legal definition, is a physical or mental impairment which substantially limits one or more major life activities. Major life activities include basically anything you can think of. Walking, jumping, standing, thinking, concentrating, reproductive functions, all sorts of bodily functions and activities. So if you have somebody that has a condition that limits one of those activities, then in theory they could have a disability. I say this just to make sure that you're aware, once you hit these 15 employees, that's when you're subject to the ADA. If someone comes to you with a potential disability, you need to know that there is an accommodation process that you have to go through. There's no formality to it. It's an informal, interactive process that I like to describe as a back and forth between the employer and the employee to try to figure out if there's something you can do to accommodate their disability. So just know, once you reach the size where you're subject to these laws, be very careful when somebody comes to you with a health-related issue. Examples of disabilities: cancer is an obvious one, vision and hearing impairment, severe back and spinal injuries, diabetes. Mental disabilities are some of the most difficult issues we encounter as defense lawyers and as employers, because it's hard to know when somebody's really suffering from a mental disability, but just know that they could potentially be protected. Alcoholism, if it's actually what's the word I'm looking for? If it's actually determined to be alcoholism by a doctor, it can be protected. Allergies is one that surprised me when I first heard it, but just know that it is out there. What is harassment? The most important thing I can tell you about harassment is just know that it's not just sexual harassment. Everybody thinks of harassment and they think, okay, well, I can't sexually harass anybody. But harassment can be based on any protected class. So you can't harass somebody based on their gender or race or marital status. Retaliation is probably one of the more dangerous claims that employers are facing. Basically, that's an employee engages in protected activity, which is a complaint about something, or a, hey, you're not paying me properly, or hey, I need to take work comp leave, or whatever. And then you take some adverse action against them, and they can prove there was a connection. The retaliation claim can be valid even if that underlying complaint wasn't valid. So some of the opposition, unlawful activity, a whistleblower, everybody knows what whistleblower is. They're complaining about something you're doing unlawfully. If they're complaining about discrimination, hours, work comp, these are all things that can lead to retaliation. Again, like I just said, retaliation can be valid even if the underlying complaint is unfounded, as long as that complaint was made in good faith. They're saying, I really believed that you weren't properly paying me, or I really believed you were discriminating against me. Even if the court says no, there's no discrimination, there could in theory be retaliation if you took action based on that complaint. The NLRB, another acronym, the National Labor Relations Board, generally is thought of to cover only union workplaces. Thankfully in Florida we don't have a lot of unions, but there is a segment of it that covers non-union workplaces as well. I bring this up because this is where the Facebook firings come in. If you have an employee or employees, it has to be 2 or more, who are getting on Facebook and they're bad-mouthing your company or they're complaining about something, you have to be very careful about the action that you take, because that, in theory, could be unlawful. I know I'm flying through some of this. Non-compete agreements. This is something you guys may want to consider once you do get your startups going and you have information to protect. Non-compete, non-solicitation, and actually confidentiality agreements as well, and our corporate lawyer will focus on these. But they are valid in Florida. A lot of people are under the impression that non-competes are not valid, but they absolutely can be valid and enforceable if they're written correctly. You have to be reasonable. You can't prohibit somebody from working ever in any business that's even remotely related to you in any location, but you can prohibit them from competing with you directly within the certain geographic area where you work. So once you get started, and if you have certain key people that you're worried about leaving and harming you, this may be something that you want to think of. You've got to be able to show that you have a legitimate business interest to protect. Again, you can't just tell somebody they can't work in the field forever. You have to be able to show that you're protecting one of these things: training, trade secrets, confidential information, customer relationships. But if you have that, then these agreements, if written properly, can definitely be enforceable. If they're overbroad or overlong, then the court can apply what's called the blue pencil rule. So let's say you want to prohibit Sally from working for a competitor for 5 years, and the court says that's too long for somebody in Sally's position. We think 2 years is appropriate. The court will blue pencil it down to 2 years to make it more reasonable. best practices. Set a good example, especially as owners of companies. You know, people are going to be looking to you as how you want your business to operate, how you want your employees to act. Consistency is absolutely key to avoiding employment lawsuits. Once you have supervisors, you want to make sure you're training them to be consistent as well. Be careful with interview questions, document. Be careful of complaints and never sweep one under the rug. Every workplace, or at least most workplaces, I would say, has that negative Nancy or that person who's always complaining about something. Be careful with the negative Nancy, because there may be a time where she's complaining about something and then you fire her and now she has a retaliation lawsuit. If in doubt, promptly report it. That's more for your supervisors than it is for you guys if you're starting companies. And then be careful about retaliation. Any questions? Who wants to hire lots of people now?
Please do not hire anyone after this, okay? Just
No.
don't. Just do it on your own.
Yeah, I know, and I say that in just, you know, obviously, once you're growing, you're gonna have to hire people. What I will say, if you take one thing away from what I've said, the best advice I can give you is to be proactive in dealing with this stuff. And I try to convince my clients all the time, just call me and ask me. You know, yes, it may cost you $50 to ask me a question, or it may cost you $500. I don't know, it depends on the question. But you're going to save so much money in the long run if I can help you avoid a lawsuit. So I would advise you, you know, as you start your companies, be on top of these things as much as you can, and you will be, even if you have to spend a few dollars up front, you will be in such better of a position going down the road. Yes.
I have a friend who was actually supposed to come with me, but he's hiring a bunch of outside sales reps, and he's sending out the paperwork, I guess it's the 1099 form, out to people.
Yeah.
How does he know, like, is there any way to tell, does he have to like contact somebody like you to have you look over it first to make sure it's all on point, or?
Yeah, because in the thing that piques my brain right there is 1099, you know, are these people really truly gonna be 1099s?
Right.
The sales is dangerous, and I have a client who actually just went through an audit where she had a lot of salespeople classified as 1099s, and the Department of Labor said, no, those are employees, because they're not working for anybody else, they're not doing the same thing for their own business, and you are telling them, you know, when to do their job, so it can be dangerous. Yeah, absolutely, have them contact somebody in advance, just to make sure, number one, that the classification is right, and then number two, assuming it is, that the document that they're signing is right. All right, well, thank you guys, I appreciate you coming. You are in a great group, so if you have questions, I'm easy to find by Google.
You have a card?
I do, I have a open card, I hope. Thank you, thanks for coming. Thank you, thank you so much. Thank you. Nice to meet you. Hope you get to know more. Thanks for coming. I'll have more cards. You have
Card,
questions?
I don't have a card, but I like one.
Okay, let me go get some more. Let's hope I have.
Thanks. Since we last time.
I've been known to give out other people's cards on accident, so I want to make sure I'm not doing it. I have two more.
Okay.
So, if I'm missing you, give me your email address, shoot you an email.
Yeah, I have.
Here, I usually have digital cards, so I'll just take a picture and.
You
can use that.
Just one.
Yeah. Yes.
You're from East.
Yeah, our corporate guy who's coming back, his name is Guy Weitzman. He is the one who can advise you whether you should have an LLC or a partnership or a Inc. Yeah, we'll definitely do that.
Guy White's.
Guy Weitzman. There are, you know, several people in his department, but he's the head, and he will be here at one of his lunch times.
Yeah, which.
So I don't remember what his name is. And it's on the website. That's
It's
awesome.
free, if you wanna use the cloud, then you got
And
it.
he's excellent.
Cool.
Thank you.
Thank you.
The only thing I didn't know. So Veronica, I'm working with a client that's lead generating for lawyers.
Okay.
And they should do their website.
Yeah, yeah.
So like, one question I was talking to it was, employers who hire who hire illegal employees,
Yeah.
and then threatens them saying that if you say anything, I will report you on the phone.
Yeah, those people are going to jail.
So is that, how is that, like,
Does that fit into my world?
how is that dealt with?
They literally, there can be criminal penalties for something like that. We knowingly employ the illegal immigrants, and then the immigrants themselves can be deported.
Because that's the thing that, cause my job is to target those customers who are looking for lawyers like that.
Okay.
So, they're usually afraid of like going to a lawyer or something.
Yeah, there are certain protections, like, for example, with the Fair Labor Standards Act, they're still gonna be required to be paid even if they are illegal immigrants. But they do run the risk of being deported if they're caught,
That's
so,
what they
and
fear
that's absolutely gonna be a challenge, for sure. So,
Alright.
yeah, they can be deported. I wish there was some other protection I could tell you.
That may help me write the content.
Yeah, they can be deported. And the bad employers can be jailed.
Just wanna fix some information. Okay. Okay.
Thank you guys for coming. Do you have any questions or anything I can help with before I?
Well, I was just on the other side. I just filed a small claims case against my former employer because all the attorneys I spoke with said there was no teeth in the case because we didn't have a signed agreement.
Okay.
But that's a whole nother discussion.
Yeah, okay. Yeah, signed agreement, depending on what it is, signed agreement certainly help, but,
Yeah.
well, I'm sorry to hear you on the bad side of that.
Hey, it worked out for the better. I'm starting another company, so I got your information. So
Good, yeah, well, let me know. I'm always happy to answer questions. And we have a blog. I don't blog as much as I used to because
Yep.
I've been busy, but if anything significant comes out, we'll put it up there. So check out the blog. We have seminars and stuff once you guys do have employees that we lots of HR type blogs.
yeah, I actually had what is it? Law Trades.
That's right there.
One of my buddies started a outsourcing, or basically he helps match accountants.
Okay.
So it's, I don't know what you call it, a platform accounting business.
Yeah, yeah, I will,
He's
I will
a
post it.
law business, which is a platform business.
Okay,
So I kind of went and checked that out,
yeah,
but, because I don't really know people here.
sure.